Before we begin, a quick and important disclaimer. The historical information and legal concepts discussed in this video regarding divorce, family law, and societal structures in early American society are intended strictly for educational and entertainment purposes. This content does not constitute professional legal advice, nor should it be used as a substitute for consulting a licensed family law attorney in your jurisdiction. Family law is highly complex, varies significantly by state, and is constantly evolving. The historical trends and case studies presented here are meant to provide context and analytical insight into how the modern legal framework was built. Viewers are strongly encouraged to conduct their own due diligence and seek qualified legal counsel for any personal domestic or legal matters. Standing in the center of a freezing, windswept town square in 17th century Massachusetts. The year is 1684, and your entire reputation, your livelihood, and your legacy are about to be publicly dismantled. You are a man of property, a blacksmith who has worked for 2 decades to build a thriving enterprise, clearing land and establishing a homestead with your own calloused hands. Yet, you are standing before the colonial magistrates, not as a respected businessman, but as a humiliated supplicant begging the court to sever your marriage to a woman who has utterly abandoned your home or betrayed your trust. You might assume that in the deeply patriarchal society of early colonial America, the system would be rigged entirely in your favor. You might assume that a man could simply dismiss his wife, retain his wealth, and move forward with his life. That assumption is one of the greatest historical illusions of our time. The shocking reality is that seeking a divorce as a man in early America was essentially a process of institutionalized self-destruction. The court proceedings were never private. They were spectacular public trials meant to enforce absolute moral conformity within the community. To secure a divorce, a man had to publicly parade his deepest domestic failures, detailing agonizing personal betrayals before a tribunal of his peers, ministers, and neighbors. He had to prove not just that his marriage was irrevocably broken, but that he was entirely and completely blameless, a standard of absolute purity that almost no human being could ever meet. If his wife or her family accused him of even the slightest provocation, neglect, or cruelty, the court would instantly dismiss his petition. This legally bound him to an empty home, while forcing him to maintain full financial responsibility for a spouse who despised him. Even if he somehow won the case, the financial ruin was often absolute. The colonial courts heavily favored the preservation of the societal unit over the individual man's happiness. The division of property, the strict assignment of dower rights that locked up his real estate, and the sheer exorbitant cost of petitioning the colonial legislature would leave men utterly destitute. In the southern colonies, the situation was even more draconian. Absolute divorce simply did not exist. A man could be subjected to egregious infidelity, profound financial sabotage, and public mockery by his spouse, and the Anglican-influenced courts would offer absolutely no legal mechanism for him to remarry or protect his assets from her debts. He was trapped in a state of legal purgatory until the day he died, forced into informal separations that left his estate vulnerable to endless litigation. This was not a system designed to protect men. It was a system meticulously designed to protect the economic stability of the colony and the local parish at the direct expense of the individual man. But here is the most terrifying part of this historical reality. The vital concept that you need to fundamentally understand before you ever sign a marriage license or step foot in a modern courthouse. The rigid, unforgiving legal frameworks, the devastating financial precedents, and the deeply ingrained societal biases against men seeking to dissolve a marriage were not left behind in the 1700s. They did not magically disappear when the country modernized and industrialized. They were quietly, methodically woven directly into the foundational DNA of the modern American family court system. The problem we are addressing today is the dangerous modern myth that family courts operate on a blank slate of pure equality and objective fairness. Every single day, men across the United States walk into divorce proceedings utterly blind to the centuries of invisible legal architecture, actively working against them. They believe they are fighting a modern legal battle, but they are actually fighting the ghosts of colonial magistrates and the deeply entrenched historical presumptions about male responsibility, culpability, and disposability. By watching this deep dive masterclass, you are going to gain a profound strategic understanding of exactly how the American legal system views men in the context of marriage and divorce, not based on what the law superficially states today, but based on the historical bedrock upon which those laws were meticulously built. We are going to completely dismantle the historical trends that birthed modern legal strategies. Take, for example, the concept of alimony. We will explore how a concept originally designed in early America to prevent destitute women from becoming financial burdens on the local colonial taxpayer has inexplicably morphed into a mechanism for indefinite wealth transfer, even in our modern era of dual-income households. You will learn the exact historical moment when society began to strip men of their automatic paternal rights, eventually replacing them with doctrines that permanently shifted the assumption of default custody away from fathers. We will examine deeply researched historical case studies of early American men who tried to navigate these treacherous waters and analyze the brutal, life-altering outcomes they faced. You will see, step by step, how the courts historically justified the absolute liquidation of a man's life's work to maintain the status quo of the surrounding community. Why does this matter to you right now? Because you cannot defend yourself against a system if you do not understand its source code. When your attorney casually explains that a judge has broad discretionary power over your financial assets, you will finally understand that this discretion is heavily influenced by a centuries-old mandate to prioritize societal welfare over your individual property rights. When you are faced with character accusations designed to publicly shame you and weaken your negotiating position, you will recognize the exact same strategic tactics used in the Puritan courts of the 1600s to establish moral superiority and extract massive financial concessions. This knowledge is your intellectual armor. We are not relying on bitter anecdotes or internet folklore. We are grounding this masterclass entirely in documented legal history, legislative records, and court transcripts from early America. By the end of this comprehensive series, you will possess a crystalline perspective on the historical forces driving modern divorce outcomes. You will understand the underlying mechanics of asset division, the historical bias inherent in custody evaluations, and the deeply rooted economic rationale behind spousal support. This is about removing the blindfold. It is about understanding that the struggles men face in family court today are not isolated incidents of bad luck or individual judicial bias. They are the direct, measurable results of a legal continuum that began over 300 years ago. You are going to learn how to read the legal battlefield. We will explore how the transition from localized agricultural economies to vast industrial societies violently altered the perceived value of a man within the family unit, shifting him from a sovereign patriarch and primary educator to a disposable utility, valued primarily for his external economic output. We will delve into the legislative debates of the post-revolutionary era, where the founding fathers themselves grappled with the concept of divorce, ultimately deciding to leave it entirely under the control of individual state legislatures. This pivotal historical decision created the chaotic, fragmented, and highly unpredictable system of state-by-state family law that continues to plague men today. This deep dive will provide you with the historical literacy required to ask your legal representation the right questions, to anticipate the institutional biases you will inevitably encounter, and to rationally navigate a system that was fundamentally designed, centuries ago, to treat you as a perpetual liability. To fully comprehend this perpetual liability, we must immediately dismantle the most pervasive misunderstanding about early American gender dynamics, a legal concept known as coverture. Under the deeply entrenched English common law system brought over by the colonists, a husband and wife became one legal entity upon marriage, and that entity was the husband. On the surface and in modern mainstream narratives, this is constantly framed as the ultimate patriarchal advantage, a system where the man held absolute power and the woman vanished legally. But when you examine the actual historical trends and the harsh reality of colonial courtrooms, you discover that coverture was fundamentally a strict transfer of absolute, crushing liability onto the shoulders of the man. Because the wife could not legally own property, sign contracts, or be sued in her own name, the husband became completely financially and legally responsible for every single action she took. Imagine if right now, in the year 2026, you discovered that your spouse had secretly racked up massive debts, destroyed property, or slandered a local business owner, and the state determined that you and you alone were legally responsible for paying the restitution, serving the jail time, or liquidating your assets to cover the damages. That is exactly what men faced in early America through the doctrine of necessaries. If a wife abandoned her husband, walked out of the homestead, and began purchasing goods, lodging, or food anywhere in the colony, the merchants legally billed the husband. If he refused to pay, the merchants took him to court, and the colonial magistrates almost universally forced the husband to liquidate his property to settle his runaway wife's debts. The court's primary objective was never fairness to the man. It was ensuring that local businesses did not suffer, and that the woman did not become dependent on the town's poor relief funds. The man was simply the closest available financial resource to drain. Let us look at the Puritan stronghold of the Massachusetts Bay Colony, which was one of the few places in the early modern world that even allowed absolute divorce. You might think this gave men an escape hatch. It was quite the opposite. The Puritans viewed marriage as a foundational civil contract essential for societal order, and breaking it was treated as a severe threat to the community. Consider the historical case study of a man we will call Thomas, living in Boston in the late 17th century. Thomas discovers his wife is openly engaging in adultery and has deserted their home. He files a petition for divorce with the colonial legislature, assuming his innocence will grant him freedom. Instead, Thomas is subjected to a terrifying public inquisition. The magistrates do not just investigate his wife, they put Thomas's entire life under a microscope. They call his neighbors, his indentured servants, and his apprentices to testify about his character, his temper, and his ability to provide. In the Puritan mindset, if a wife strayed or rebelled, the court strongly presumed that the husband had failed in his religious and legal duty to govern his household properly. If a single witness testified that Thomas had spoken harshly to his wife, failed to provide adequate firewood, or was absent too often working his trade, the court would rule that he contributed to her delinquency. His petition for divorce would be denied, he would be publicly censured or fined, and he would remain legally bound to her, fully liable for her actions and debts, for the rest of his life. This was the reality of the fault-based divorce system. It required a man to prove impossible, absolute purity in a society that inherently blamed him for the failures of his dependents. The situation was even more rigid in the southern colonies like Virginia and South Carolina, which rigidly followed the Anglican Church's doctrine. In these regions, absolute divorce, the legal severing of the marital bond allowing a man to remarry, was completely non-existent. The absolute highest form of relief a man could hope to achieve was a legal separation known as divorce a mensa et thura, which translates to divorce from bed and board. Imagine being a successful tobacco planter in 1750. Your wife fundamentally betrays the marriage, perhaps even attempting to ruin your estate. You take the incredibly costly step of hiring lawyers to petition the colonial court for a separation. If you win, you are granted the right to live physically apart from her. But the marriage remains entirely intact. You are completely barred from ever remarrying or producing legitimate heirs with another woman. Even worse, the court would almost certainly force you to carve out a massive portion of your estate to provide for her separate maintenance, regardless of her behavior. The court would assess your wealth, your land, your slaves, and your crops, and mandate a heavy annual payout. If the crops failed, or if the market collapsed, your obligation did not change. Men were routinely driven into bankruptcy and forced to sell off generational lands simply to meet the court-ordered maintenance of a spouse who had betrayed them, all because the colonial government absolutely refused to let the financial burden of a separated woman fall upon the public treasury. Furthermore, you could not simply sell your property and flee. Every piece of real estate a man owned in early America was heavily encumbered by a legal concept known as dower rights. Even in a state of deep marital conflict or physical separation, a man's wife held a legally protected life interest in 1/3 of all the real estate he acquired during the marriage. This meant a man could not sell his own farm, his own tavern, or his own blacksmith shop to raise capital or pay off debts, unless his wife voluntarily signed a legal document waiving her dower rights. If she hated him, she simply refused to sign. This effectively froze the man's assets, destroying his liquidity and rendering his property practically unsellable. He was geographically and financially locked in place, held hostage by the property rights granted to a spouse who no longer lived with him. The colonial legal system essentially weaponized a man's own property against him to ensure he could not escape his lifelong financial obligations. These brutal mechanisms of coverture, strict fault-based public trials, unbreakable Southern marriages, and crippling dower rights created an environment where marriage was the highest-risk financial venture a man could ever undertake. Men learned quickly that the legal system viewed them not as individuals deserving of happiness, but as lifelong financial guarantors for the state. But as the 1700s drew to a close, a massive societal earthquake was brewing that would completely upend these colonial laws. The colonies were about to violently tear themselves away from British rule, demanding liberty and individual rights in the American Revolution. You would assume that the Founding Fathers, the architects of freedom, would completely dismantle this oppressive family court framework and liberate men from these draconian marital laws. But the exact opposite happened. The revolution did not free men from the financial chains of marriage. It created an entirely new, incredibly dangerous legal weapon that would eventually evolve into the modern alimony system that strips wealth from men to this very day. And you need to see exactly how they built this trap. The American Revolution was pitched as the ultimate rebellion against tyranny, a glorious severance from the absolute power of the British monarchy and its oppressive ecclesiastical courts. But for men trapped in broken marriages, the revolution did not bring liberation. It simply transferred the power of absolute tyranny from a king across the ocean to a new hyperlocal authority, the state legislature. Because the Founding Fathers deeply distrusted the English church courts that traditionally handled family matters, they refused to create federal family courts. Instead, they handed the power of divorce directly to politicians. To understand how the modern financial trap of alimony was constructed, you must understand the terrifying machinery of the early American legislative divorce. Imagine if today, right now in the year 2026, you could not simply file paperwork at a local courthouse to end your marriage. Imagine if, to get a divorce, you had to literally lobby your state senate, run a political campaign against your spouse, and have your state representatives vote on whether you were allowed to be single again. That was the brutal reality for men in the post-revolutionary period. Getting a divorce was not a legal process. It was an exhausting, phenomenally expensive political spectacle. Let us look at a historical scenario to illustrate the sheer devastation of this system. Consider a man named John, a moderately successful shipbuilder living in Maryland in 1795. John's wife has abandoned the home and actively begun sabotaging his business reputation in the town. To sever this destructive bond, John cannot just see a judge. He must first hire a specialized attorney to draft a formal legislative petition. Then, he must physically travel to the state capitol and find a politician willing to sponsor his bill on the assembly floor. But the state requires him to give public notice, meaning John is legally mandated to purchase space in the local newspapers, running humiliating advertisements for months, explicitly detailing the failures of his marriage so his wife and any local creditors are aware of his intentions. While John is waiting for the legislative session to begin, his business grinds to a halt. In early American society, business was run entirely on credit and reputation. The moment the newspaper notice is run, John's suppliers panic. They know that if the legislature grants the divorce, they will almost certainly extract a massive portion of John's shipyard to provide for his wife. Fearing he will become insolvent, merchants cut off his supply of lumber and iron. John is financially bleeding out before the politicians have even read his name. When the assembly finally convenes, John's life is put on public display. His marriage is debated by politicians who do not know him, who have never visited his home, and who are entirely motivated by political optics. If John happens to vote for the opposing political faction, or if his wife's father is a prominent financial donor to the local representatives, John's petition is doomed. The politicians would simply vote down his bill out of spite or political favoritism, leaving John completely legally and financially bound to his wife forever. But what if John actually wins? What if the legislature votes to grant the divorce? This is the exact historical moment where the modern weapon of alimony was forged. The state legislatures realized that by granting these divorces, they were creating a massive problem for themselves. Under the laws of coverture we discussed earlier, women had no independent wealth. If the state severed the marriage, the woman would instantly become destitute, meaning she would become a ward of the state, reliant on the town poorhouses and public tax funds. The politicians absolutely refused to let the financial burden of these women fall onto the local taxpayers. Their solution was brilliantly cruel and mathematically devastating for men. Instead of reforming property laws to allow women to work or own businesses independently, the state legislatures invented statutory alimony. They codified a legal mandate that explicitly forced the husband to continue funding the woman's life indefinitely, even after the marriage was completely dissolved, and even if she was entirely at fault for the destruction of the relationship. The logic was cold and calculated. The state viewed the man's business, his land, and his future labor not as his private property, but as a public insurance policy. John the shipbuilder would be granted his freedom, but the legislature would order him to surrender half of his shipping vessels and pay a permanent annual stipend to his ex-wife. If the economy collapsed, if a storm sank his remaining ships, his mandated payments did not decrease. If he failed to pay, he was thrown into debtor's prison. The modern concept of alimony was not born out of a progressive desire for fairness. It was invented as a punitive tax designed specifically to protect the government treasury, by draining the individual man. By the 1820s and 1830s, this system became entirely unsustainable. Hundreds of men and women were flooding the state capitals with petitions. State assemblies were spending half their legislative sessions arguing over individual marriages, instead of building roads or managing the economy. The politicians needed a more efficient machine to process the destruction of marriages, so they systematically transferred the power of divorce from the legislative branch to the judicial branch, establishing the early framework of the family courts we know today. But here is the critical trap that men walk into blindly. When the politicians handed divorce over to the judges, they permanently transferred the underlying legislative mandate with it. They explicitly instructed the early judges to prioritize the financial protection of the state above the property rights of the man. They gave judges incredibly broad, unchecked discretion to liquidate a man's assets, seize his business, and garnish his future wages to ensure his former spouse never required public assistance. This created a terrifying state-by-state chaos, because the Founding Fathers intentionally left family law out of the United States Constitution. Every single state developed its own bizarre, contradictory rules for extracting wealth from men. A man could finalize a divorce in Connecticut, surrender his property, cross the border into New York to start a new life, and suddenly be arrested for bigamy because New York refused to legally recognize the Connecticut decree. He was treated as a fleeing criminal, a legal fugitive whose wealth was perpetually vulnerable. Despite this absolute financial destruction, early American men still clung to one solitary powerful legal right. Under the ancient rules of English common law, the children were considered the absolute responsibility and the rightful heirs of the father. Even if the court liquidated a man's business and drained his bank accounts, he retained full custody of his children, preserving his legacy and his workforce. But as the smoke of the Industrial Revolution began to fill the skies, society realized that simply separating a man from his money was not enough to maintain the new economic order. They needed to fundamentally sever him from his bloodline. The courts were about to invent a psychological legal weapon so profoundly devastating that it would permanently rewrite the definition of fatherhood, transforming men from the undisputed, sovereign heads of their households into disposable weekend visitors holding a child support receipt. You are about to see exactly how the American legal system stole the children. To understand the sheer magnitude of this legal robbery, we must first look at the unshakable foundation it replaced. For centuries under English common law, which the early American colonies strictly inherited, the legal presumption of child custody was entirely unapologetically paternal. A father held the absolute, unquestioned legal right to his children. This was not born out of some arbitrary patriarchal cruelty, but out of a rigid economic equation. In an agrarian society, children were not viewed merely as emotional companions. They were critical economic assets. They were the essential labor force required to run a farm, manage a trade, and ensure the survival of the family estate. Because the father was legally bound by the state to financially provide for the household and pay the debts, the law dictated that he was entitled to the labor and the loyalty of his children in return. The courts considered the father the natural guardian, the moral instructor, and the sole legal representative of his offspring. A mother possessed no legal standing to claim custody. If a marriage dissolved, the children stayed with the man, period. The colonial magistrates understood that stripping a man of his workforce would inevitably bankrupt him, and as we have established, the colonial state was terrified of bankrupt men who could not pay taxes. But as the 19th century dawned, the rumblings of the Industrial Revolution fundamentally fractured this ancient social contract. The rapid shift from localized, self-sustaining agriculture to urbanized, factory-based wage labor physically ripped the man out of the home. For the first time in human history, the physical location of economic production was separated from the physical location of the family. Men were forced to travel to mills, foundries, and counting houses, leaving the homestead for 12 to 14 hours a day. This sudden, violent restructuring of society created a massive void in the daily management of children, leading to the invention of a brand new societal concept, known as the doctrine of separate spheres. Society suddenly decided that the brutal, competitive public world of industry and commerce was the exclusive domain of men, while the quiet, domestic, private world of the home was the exclusive, natural domain of women. This cultural shift might seem harmless, but it handed early family courts the ultimate philosophical weapon to sever the paternal bond. The courts began to adopt a completely novel, highly sentimental view of childhood. Children were no longer viewed as rugged economic assets. They were suddenly redefined as fragile, vulnerable creatures requiring specialized, innate emotional nurturing. And who possessed this magical inherent capacity for nurturing? According to the male judges of the 19th century, it was strictly the mother. This led to the creation of the most destructive piece of family law jurisprudence ever conceived, the tender years doctrine. Originating in English law and rapidly infecting American state courts by the 1830s and 1840s, this doctrine essentially declared that during a child's early developmental years, roughly from birth until age 7 or sometimes older, the mother was the biologically necessary and legally superior parent. The court suddenly flipped the centuries-old presumption on its head. Now, a man entering a divorce proceeding was no longer the assumed custodian of his legacy. He was legally presumed to be entirely unequipped, biologically deficient, and emotionally incapable of raising his own offspring. Imagine if right now, in the year 2026, you walked into a courtroom and the judge looked at you, a dedicated father named Harrison who has worked tirelessly to build a secure life for his family, and told you that your very biology disqualifies you from raising your toddlers. Imagine the state declaring that despite your impeccable character, your financial stability, and your deep devotion, you are inherently defective as a parent simply because you are male. This is not a hypothetical nightmare. This is the exact legal reality that men like Harrison face today, heavily influenced by a doctrine written nearly 200 years ago. Under the tender years doctrine, the burden of proof violently shifted. A man no longer had to simply show he was the head of the household. He had to affirmatively prove that the mother was utterly, irredeemably unfit. He had to prove she was destitute, profoundly mentally unstable, or a public menace. If she was simply average, she won the children by default. Let us look closely at the devastating historical trends this created. A mid-19th century man could petition for divorce due to his wife's blatant infidelity. He could win the divorce, proving his innocence and her betrayal. Yet, under the insidious application of the tender years doctrine, the judge would look down from the bench and rule that despite her moral failings as a wife, her biological nature still made her the superior mother to an infant. The man would be granted his legal freedom, but he would watch his children be handed over to the very person who destroyed his home. He would be stripped of his heirs, his legacy, and the daily joy of fatherhood, relegated to the role of a peripheral, visiting stranger. But the legal system was not finished with him. The courts quickly realized that if they gave the children to the mother, who under the lingering shadows of coverture still had highly restricted earning potential, the mother and children would starve. Once again, the state refused to absorb this cost. Therefore, the judges brilliantly chained the old laws of paternal financial responsibility to the new laws of maternal custody. The court stripped the man of his absolute right to his children, but legally retained his absolute duty to pay for them. He was transformed into an external funding source, a walking ATM whose sole societal value was the extraction of his wages to finance a household. He was no longer permitted to inhabit or govern. The psychological toll on men during this era was catastrophic. You must understand that these early American men were raised to believe that their ultimate societal duty and personal honor were tied to guiding their children to adulthood. To be publicly stripped of that right, to be legally branded as an inadequate guardian based solely on gender, was a profound public humiliation. It shattered the very definition of masculinity that these men had been taught to revere. They were reduced to spectators in their own family lines, forced to endlessly finance the rearing of children who were legally alienated from their influence. This system deliberately trained children to view their fathers not as mentors or protectors, but merely as a source of incoming capital, a dynamic that has thoroughly infected modern co-parenting relationships. This calculated legal maneuver created a massive underclass of disenfranchised, financially drained men who quickly realized they were trapped in a no-win scenario. They were paying exorbitant alimony, funding separate households, and being denied access to their own bloodline. The entire system was perfectly designed to extract their labor, while denying them any familial authority. So, these men began to do the only logical thing left to them. They began to run. They abandoned their hometowns, crossed state lines, and disappeared into the expanding American frontier, desperately trying to outrun the financial judgments and the crushing weight of a family court system that had stolen everything. But the government was watching. The politicians and judges realized their extraction machine was leaking revenue, and they were about to build a brutal, inescapable federal apparatus to hunt these men down, turning the full force of the United States government against them. You need to see exactly how they built the dragnet. The phenomenon known to 19th-century lawmakers as the runaway husband was not a spontaneous wave of moral failing. It was a highly predictable economic migration. When the state systematically deployed the tender years doctrine to sever a man from his children, and simultaneously utilized the crushing machinery of permanent alimony to siphon away his labor, it mathematically destroyed his localized future. Men realized that staying in their home jurisdictions meant living as indentured servants to a marriage that no longer existed. So they utilized the greatest geographic advantage early America had to offer: the vast, rapidly expanding western frontier. The construction of the transcontinental railroads and the explosive growth of frontier boomtowns provided an unprecedented opportunity for complete anonymity. A man could board a train in Boston, disembark in a Colorado mining camp, assume a slightly altered name, and simply vanish from the legal radar of his eastern magistrates. This mass exodus triggered an absolute financial panic among state legislatures on the East Coast. When these men vanished, the mandated alimony and child support payments immediately ceased. Consequently, their former wives and legally alienated children instantly fell onto the local public relief rolls. The state was suddenly forced to subsidize the very families they had promised to protect through their draconian family court rulings. Politicians recognized that their carefully constructed system of wealth extraction was completely entirely dependent on the physical presence of the man. If the man crossed a state line, the system collapsed. The local county treasuries were bleeding capital, and the politicians demanded an immediate, ruthless solution. They needed to weaponize the invisible borders between states. Let us examine the historical trends through the lens of a mid-19th century man named Thomas, a skilled carpenter residing in New York. Thomas undergoes a brutal, public fault-based divorce where he loses custody of his 3 children and is ordered to pay 60% of his future earnings in separate maintenance. Realizing he will starve if he complies, Thomas packs his tools and flees to the booming industrial center of Chicago, Illinois. In the early days of this migration, Thomas was safe. A New York civil judgment for alimony was considered virtually useless in an Illinois court. The local judges in Chicago had zero interest in enforcing the decrees of a New York magistrate, especially when Thomas was contributing his highly valuable labor to the local Illinois economy. The jurisdictional boundaries acted as impenetrable shields for fleeing men. To shatter this shield, state legislatures began a highly aggressive legal campaign to reinterpret the full faith and credit clause of the United States Constitution. Originally intended to ensure states respected public records and basic legal proceedings, aggressive lawmakers began arguing that a family court decree of financial extraction from one state must be strictly enforced by the police power of another. But civil judgments were slow, cumbersome, and incredibly difficult to enforce across thousands of miles. The state needed a mechanism to physically drag men back to the jurisdiction where they were financially condemned. The solution they engineered was the criminalization of abandonment. Politicians systematically transformed the failure to pay civil family court judgments into a severe criminal offense, passing the first waves of criminal non-support and desertion laws. This was a profound and terrifying escalation. A man who could not pay his ex-wife was no longer just a civil debtor. He was legally rebranded as a fleeing felon. By attaching criminal warrants to these family court financial mandates, states unlocked the power of interstate extradition. If Thomas the carpenter failed to send his extortionate payments back to New York, the New York magistrates would issue a criminal warrant for his arrest, forward it to the Chicago police, and demand his physical extradition back across the country. Thomas would be arrested at his new job, locked in chains, placed on a train under armed guard, and dragged back to New York to face debtor's prison. This historical pivot is precisely why you cannot outrun the system today. Imagine if right now, in the year 2026, a man named Daniel attempts to escape a devastating child support and permanent alimony order by relocating from California to Texas, assuming a new job in a completely different sector. He believes the distance will protect him. But Daniel is walking straight into the fully matured version of the exact federal dragnet designed in the late 19th century. Today, through federal mandates like the Uniform Interstate Family Support Act and Title 4D of the Social Security Act, the state does not need to send an armed sheriff on a train. The moment Daniel begins his new job in Texas, his Social Security number triggers an automated federal database. Within days, his new employer receives a legally binding interstate income withholding order. The state of California reaches seamlessly across the country, bypasses Daniel entirely, and surgically extracts the capital directly from his Texas paycheck before he ever sees a single dollar. Furthermore, if he attempts to leave the country, the federal government automatically suspends his passport. The inescapable surveillance grid Daniel faces today is the direct technological descendant of the early criminal non-support laws, designed to hunt down frontier men. As the extradition dragnet tightened, men realized that simply running away was no longer a viable long-term survival strategy. They could not outrun the warrants, so they decided to outmaneuver the laws. This birthed the chaotic, highly controversial era of the migratory divorce. Men discovered that because the United States Constitution allowed states to set their own family laws, certain Western territories were desperate to attract population and capital. States like Indiana and later territories like Nevada and the Dakotas intentionally created incredibly lenient, rapid divorce laws specifically designed to lure wealthy men away from the oppressive Eastern courts. A man could board a train to Sioux Falls, establish legal residency in a matter of weeks by living in a hotel, and secure a rapid divorce decree that completely bypassed the crushing alimony requirements of his home state. This triggered an absolute legal war between the states. A man would return to New York holding a legally binding divorce decree from South Dakota, declaring himself a free man. His furious ex-wife would immediately petition the New York courts, arguing that the South Dakota decree was a fraudulent sham. The New York judges, fiercely protective of their jurisdiction and terrified of the resulting financial burden, would routinely strike down the Western divorces, declaring the man still legally married and still entirely financially liable. This resulted in men being legally divorced in one state and legally married in another, a chaotic legal purgatory where a subsequent marriage could result in felony bigamy charges depending entirely on which side of a state border the man happened to be standing. By the turn of the 20th century, the American family court system was buckling under its own catastrophic weight. The endless interstate legal warfare over migratory divorces, the massive public spectacles of fault-based trials, and the sheer logistical nightmare of extraditing thousands of financially ruined men across the country was paralyzing the judicial system. The dockets were completely clogged. The politicians and the judges realized that the old colonial machinery of fault and punishment was too slow, too messy, and too inefficient for a rapidly modernizing industrial society. They needed a streamlined, frictionless mechanism to dissolve marriages and redistribute male wealth without the cumbersome requirement of proving absolute guilt or innocence. They needed to invent a completely new legal doctrine, a silent, administrative execution that would completely strip away a man's constitutional right to face his accuser and defend his legacy. They were about to unleash a legal concept so utterly devastating, so meticulously designed to blindside the American man, that its shockwaves are still the primary driver of male bankruptcy today. You are about to discover the terrifying true origin of the no-fault divorce system. To comprehend the true origin of the no-fault divorce system, we must first analyze the absolute theatrical farce that the American courtroom had become by the late 19th century. The rigid, unforgiving fault-based system we previously examined, heavily rooted in colonial religious doctrines, had created an impossible bottleneck. In powerful jurisdictions like New York, the absolute only legal ground for a full divorce was adultery. There was no mechanism for irreconcilable differences. If a husband and wife simply despised each other, or if the marriage was a deeply hostile, toxic environment, the state legislature fundamentally did not care. The state mandated that they remain legally fused together forever, paying taxes, raising future laborers, and maintaining the societal facade. This draconian rigidity birthed a massive, highly lucrative underground industry of institutionalized perjury and widespread legal collusion that would ultimately force the legal system to rewrite its own rules. Because the courts explicitly demanded a villain to justify the dissolution of the contract, society created a bizarre, unspoken gentleman's agreement where the man was almost universally expected to absorb the legal blow to protect the social standing of the woman. Let us break down the exact step-by-step historical trends of how a wealthy man in this era practically dissolved his marriage. He could not simply file administrative paperwork at a local clerk's office. Instead, he would hire an attorney who specialized in staging marital crimes. The attorney would then hire a private investigator and an unknown woman, often an aspiring actress or a local sex worker. The husband would travel to a predetermined hotel, check into a room with this hired woman, and leave the door intentionally unlocked. At a highly specific, prearranged time, the private investigator, accompanied by a hired photographer, a bellhop as an independent witness, and sometimes even the wife's own attorney, would aggressively burst into the hotel room. They would document the husband in a state of partial undress with the unknown woman, creating an irrefutable, physically documented scene of blatant infidelity. This entirely fabricated event was then brought before a family court judge. Everyone in the courtroom, the judge, the bailiffs, the attorneys, and the spouses, knew precisely that the entire spectacle was a manufactured lie. Yet, they all played their meticulously assigned roles in this grand legal theater, because it was the only possible way to satisfy the state's archaic requirement for absolute fault. The man willingly accepted the public branding of an adulterer, because he mistakenly believed it was the only path to his personal freedom. But this is exactly where the trap was triggered, a trap that fundamentally reshaped the economic future of American men. Imagine if right now, in the year 2026, a man named Christopher, a highly successful architect, is trapped in a deeply dysfunctional and irredeemable marriage. To escape, Christopher is legally advised to publicly confess to a massive corporate embezzlement scheme he never committed, simply to satisfy a bizarre bureaucratic checklist required to nullify a contract. He assumes this confession is just a procedural formality to get the paperwork stamped by a judge. But the exact moment Christopher signs that written confession, the state immediately seizes his commercial bank accounts, liquidates his real estate investment portfolios, and garnishes 60% of his future professional wages, using his own fabricated confession of corporate theft as the absolute, ironclad legal justification for his total financial ruin. This is precisely what happened to the men participating in the staged hotel raids of the late 19th and early 20th centuries. By intentionally providing the court with documented, photographic evidence of their own adultery to secure the divorce decree, these men completely voluntarily handed the judge the exact legal ammunition required to justify massive, permanent alimony awards. The courts utilized the man's admitted, documented fault to aggressively strip him of his assets, transferring his property, his business capital, and his future labor to the supposedly innocent wife. Men were systematically trading their financial futures and their generational wealth just to bypass the archaic, puritanical legal barriers of the era. As the 20th century accelerated, the sheer volume of this blatant perjury began to deeply embarrass the judicial system. Politicians and legal scholars realized that the state was essentially functioning as a willing co-conspirator in mass public fraud. To bypass the scandalous and highly publicized hotel raids, courts began to quietly expand the definition of fault, introducing the highly subjective, deeply dangerous concept of extreme mental cruelty. This was a catastrophic historical shift for men. Suddenly, a wife did not need to prove that her husband was a convicted criminal, a physical deserter, or a documented adulterer. She simply had to convince a sympathetic judge that his everyday, routine behavior caused her profound emotional distress and psychological instability. The historical trends show a rapid, terrifying weaponization of this new legal standard. A man could be dragged into court and legally accused of extreme mental cruelty simply because he refused to socialize with his wife's extended family, because he read the evening newspaper at the dinner table in a sullen manner, or because he worked too many hours at his trade and allegedly neglected her emotional needs. The burden of proof plummeted violently from objective, physical evidence to highly subjective, emotionally driven interpretations of a man's daily existence. But for the American man, this supposedly progressive evolution was the final devastating turn of the key in his legal prison. You must deeply understand the brutal mathematics of what the legal system actually accomplished with this shift. Under the old, corrupt, fault-based system, no matter how rigged or theatrical it was, a man who was genuinely innocent still retained a powerful theoretical legal shield. If his wife demanded a divorce and a massive, disproportionate share of his hard-earned assets, but she could not definitively prove he had committed a marital crime, the man could effectively block the divorce. He could leverage his absolute innocence to protect his commercial property, his business, and his foundational access to his children. His lack of fault was his ultimate, defining negotiating power. The implementation of the no-fault system completely vaporized that defensive shield. It established a terrifying new legal paradigm where the state granted one party the absolute, unilateral power to completely terminate the foundational marital contract at any time, for any reason, or for no reason at all, without any requirement to prove a breach of that contract. More importantly, it allowed the state to forcefully liquidate a man's assets, divide his property, and mandate heavy future wealth transfers, even if the man had flawlessly fulfilled every single moral and financial obligation of his marriage vows. The state fundamentally decoupled financial punishment from behavioral culpability, turning the family court into a blind, administrative meat grinder. The legal system had successfully engineered a frictionless, highly efficient extraction machine that could completely dismantle a man's life's work without ever requiring him to commit a single offense. But the architects of this modern system completely failed to anticipate a dark, incredibly destructive unintended consequence. By completely removing the requirement of fault to secure the divorce decree itself, they accidentally created a massive, desperate vacuum in the secondary battle for child custody and financial leverage. If a spouse could no longer use a man's documented bad behavior to secure the lion's share of the estate under the law, they needed a completely new, infinitely more destructive weapon to forcefully tip the scales of judicial discretion in their favor. You are about to see exactly how this administrative vacuum birthed the most dangerous, life-destroying tactic in the entire modern family court playbook, a strategy of calculated, preemptive annihilation that continues to obliterate American fathers to this very day. The legal vacuum created by the gradual dismantling of the fault-based system birthed a terrifying new strategic imperative for divorce attorneys. If a spouse could no longer guarantee a massive financial windfall or absolute custody of the children by publicly proving a man was an adulterer or a criminal, they had to find a way to rig the game before the man even knew he was playing. They needed a mechanism to instantly strip him of his assets, his home and his children without ever having to face him in a fair, open trial. The historical trends show that the legal framework for this calculated, preemptive annihilation was quietly adapted from the ancient English courts of chancery, specifically through the weaponization of a legal concept known as the ex parte proceeding. Ex parte is a Latin legal term that translates to from one party. In the foundational bedrock of American constitutional law, every citizen is guaranteed the absolute right to due process. This means that before the state can strip you of your property, your liberty, or your children, you have the fundamental right to be notified of the accusations against you, the right to secure legal counsel, and the right to stand in open court to face your accuser and present a defense. The ex parte proceeding is the nuclear exception to this constitutional guarantee. It allows one party to walk into a judge's chambers in complete secrecy, entirely without the knowledge or presence of the accused, and present sworn affidavits demanding immediate emergency action. In early American commercial law, these emergency injunctions were strictly limited to preventing profound financial catastrophes, like stopping a corrupt business partner from burning down a warehouse or loading stolen goods onto a ship set for Europe. But as the family courts modernized and the battle for child custody and alimony intensified, aggressive legal strategists realized they could port this commercial emergency mechanism directly into the domestic sphere to execute a devastating first strike against a husband. Imagine if right now, in the year 2026, a man named Michael returns home from a grueling 12-hour shift at the hospital where he works as a respiratory therapist. He pulls into his driveway, expecting to greet his children and eat dinner. Instead, he finds the locks to his own house have been completely changed. Taped to the front door is a legally binding emergency protective order, or an ex parte temporary restraining order, signed by a family court judge just hours earlier. In an instant, without a single police investigation, without a single criminal charge, and without Michael ever stepping foot inside a courtroom, the state has legally rendered him homeless. He is instantly barred, under threat of immediate felony arrest, from entering his own property, accessing his own personal belongings, or coming within 500 feet of his own children. Michael has been neutralized with a single stroke of a judge's pen, based entirely on a one-sided piece of paper drafted in secret by his spouse's attorney. To understand how this became standard operating procedure, we must examine the historical case studies of the late 19th century. Consider a wealthy mercantile trader named Robert operating in Chicago in 1894. Robert's marriage is dissolving, and his wife's legal team knows that if they proceed to a standard trial, Robert will utilize his massive financial resources to secure a highly favorable settlement. To prevent this, her attorneys file a secret emergency petition. They draft a highly exaggerated sworn affidavit claiming that Robert possesses a violent temper, that the home is unsafe, and most importantly, that he is secretly conspiring to liquidate his warehouse assets and flee the jurisdiction. The 19th century judge, terrified of the potential liability and deeply influenced by the era's prevailing presumption of female vulnerability, signs the writ of injunction. Robert arrives at his counting house to find it padlocked by the sheriff. This preemptive strike accomplishes three devastating strategic objectives simultaneously, establishing a triad of destruction that is still utilized in modern family courts today. First, it instantly dictates the legal concept of the status quo. Family court judges are historically terrified of disrupting the lives of children. By using an emergency order to physically eject the father from the home, The opposing attorney instantly establishes the mother as the sole, de facto primary caregiver and the exclusive occupant of the marital residence. When the actual custody hearing finally takes place, sometimes months or even a year later, the judge will look at the situation and rule that since the children have been living safely with the mother in the family home for the past several months, it is in their best interest to maintain that newly established status quo. The temporary, emergency exclusion of the father seamlessly hardens into permanent, legally mandated alienation. The second objective is total financial starvation. When a man like Michael or Robert is hit with an ex parte order, he does not just lose his home. He is plunged into a financial nightmare. He is suddenly forced to secure immediate, expensive alternative housing, purchase a new wardrobe for work, and retain a highly specialized defense attorney on an emergency retainer. Simultaneously, the family court will almost universally mandate that he must continue to pay the primary mortgage, the utilities, and the insurance on the house he is legally forbidden from entering, while also paying temporary child support. This is not an accident. It is a meticulously calculated strategy of financial attrition. The goal is to drain the man's capital so rapidly and so thoroughly that he becomes incapable of funding a prolonged legal defense. He is starved out of the legal arena, forced to accept a ruinous, heavily compromised final settlement simply because he can no longer afford to pay his attorney to fight. The third and perhaps most insidious objective is the absolute inversion of the burden of proof. In the American criminal justice system, a man is presumed innocent until the state proves his guilt beyond a reasonable doubt. But when a family court judge signs an ex parte emergency order based on an accusation of domestic instability or cruelty, that presumption is violently flipped. The man is fundamentally treated as guilty the moment the ink dries. When he finally gets his delayed opportunity to stand before the judge at the evidentiary hearing, he is not starting from a position of neutral innocence. He is starting from a deep defensive trench, carrying the massive, almost impossible burden of proving a negative. He must bankrupt himself to legally prove that he did not do the things he was secretly accused of doing months earlier. He is fighting a ghost, attempting to dismantle a deeply entrenched prejudice that has already been codified into a court order. This weaponization of emergency proceedings completely bypasses the messy, unpredictable nature of a fair trial. It allows one party to weaponize the awesome coercive power of the state police apparatus to achieve an overwhelming tactical advantage in a civil financial dispute. The courts historically allowed this terrifying loophole to remain open, because they operated under the deeply flawed assumption that judges would easily be able to spot false or exaggerated allegations during the follow-up hearings. But the judges quickly realized they were entirely unequipped to parse through the massive influx of conflicting, highly emotional domestic testimonies. They were drowning in allegations, unable to determine which men were actual threats, and which men were simply the victims of calculated legal assassination. To solve this crisis of information, the court system decided it could no longer rely on the judges alone. They needed to invent a massive, highly subjective, and deeply unregulated secondary bureaucracy to investigate the private lives of American families. They birthed a shadowy industry of unelected officials who were suddenly handed the absolute power to dictate a man's psychological fitness and determine the ultimate fate of his children. And the sheer corruption of this new system would change the American family forever. To fully grasp how this shadowy industry hijacked the American legal system, we must examine the late 19th and early 20th centuries, a period deeply obsessed with the emerging fields of psychology, psychoanalysis, and progressive social reform. State judges, entirely drowning in massive dockets of conflicting sworn affidavits and heavily manipulated ex parte hearings, desperately sought a way to outsource their terrifying constitutional duties. They were legal scholars, not domestic behavioral experts, and they needed an ostensibly objective third party to physically enter the fractured home, investigate the private lives of the citizens, and tell the court exactly who was telling the truth. This desperation birthed the invention of the court-appointed social investigator, the early iteration of the modern guardian ad litem or custody evaluator. On paper, heavily promoted by the progressive reformers of the era, this seemed like a brilliantly rational, enlightened solution. A highly trained, neutral professional would interview the parents, observe the children, and present a scientifically grounded, unbiased report to the presiding judge. But the brutal historical reality was a terrifying, unchecked transfer of absolute judicial power to a fundamentally unregulated, highly biased class of individuals operating entirely outside the traditional rules of legal evidence. These early social investigators were categorically not neutral, objective scientists. They were deeply steeped in the very same societal biases we explored earlier, specifically the absolute, unquestionable supremacy of the maternal bond dictated by the tender years doctrine. When an early 20th century investigator walked into a man's household, she was not objectively cataloging his virtues or his historical role as the patriarch. She was actively, aggressively hunting for his disqualifying behavioral flaws. Let us analyze a historical case study to see exactly how this psychological weapon was deployed. Imagine a man named William in the year 1915, working as a highly skilled foreman at an industrial steel mill in Pennsylvania. His marriage collapses, and the state court appoints a social investigator to determine the physical placement of his children. William works grueling mandatory 10-hour shifts 6 days a week to provide a secure financial foundation for his family, which was a completely standard and highly respected practice for a man of his era. But the social investigator, viewing the family strictly through the new highly sentimentalized lens of intensive emotional parenting, completely ignores his financial sacrifice. She notes in her official, legally binding report that William is emotionally distant, chronically absent from the domestic sphere, and fundamentally lacks the delicate, nurturing temperament biologically required to raise a child. She takes his greatest societal virtue, his relentless, crushing work ethic that literally keeps the family from starving, and successfully weaponizes it into a severe psychological defect. The true constitutional horror of this bureaucratic system was the overwhelming legal weight these unsworn reports carried inside the courtroom. When the investigator submitted her final written findings to the judge, it was almost never treated as a mere subjective opinion or a debatable piece of evidence. It was treated as unassailable, scientifically proven gospel. A family court judge, overwhelmed with processing dozens of broken marriages a week, would rarely read beyond the final concluding paragraph. If the investigator explicitly recommended that the mother receive full physical custody and the father be permanently reduced to a peripheral visitor paying maximum child support, the judge would simply rubber stamp the recommendation, instantly converting a stranger's subjective opinion into a permanent, enforceable court order. Furthermore, this new bureaucracy completely obliterated the ancient legal protections against hearsay. In a standard criminal or civil trial, a witness cannot legally testify about rumors or what someone else told them. They must testify to what they personally witnessed. But the court-appointed investigator was granted a terrifying, exclusive exception. The investigator could interview a hostile neighbor, a disgruntled former servant, or a bitter mother-in-law, and write their unverified, malicious rumors directly into the official court report. Those rumors instantly bypassed all rules of evidence and became established legal facts against the father, entirely stripping him of his constitutional right to cross-examine his actual accusers. Imagine if right now, in the year 2026, a dedicated father named David is fighting a desperate legal battle to maintain access to his children. The modern family court mandates a comprehensive psychological custody evaluation. David is forced to pay $10,000 directly out of his own pocket to a court-appointed forensic psychologist who meets with him for exactly 4 hours. During those 4 hours, David is understandably exhausted, highly stressed, and intensely defensive about the prospect of losing his entire bloodline. The psychologist observes his defensive posture, misinterprets his rational fear as underlying aggression, and formally labels him as hostile, rigid, and lacking empathy, completely ignoring the sheer systemic trauma of the process itself. That single highly subjective psychological label, generated in a tiny 4-hour window by an unelected, financially compensated stranger, becomes the permanent, inescapable lens through which the entire judicial system views David. He is mathematically stripped of his children not because he committed any crime, not because he is a danger, but simply because he failed a pseudoscientific personality test specifically designed to pathologize standard male stress responses. This modern nightmare is not a new phenomenon. It is the direct, unedited continuation of the early 20th century investigative bureaucracy that was built specifically to bypass the burden of legal proof. But the system was not merely philosophically corrupt. It rapidly evolved into a highly predatory financial ecosystem. The early state courts quickly realized they could legally force the father to personally finance the very same investigative apparatus that was actively dismantling his family. The court would mandate that the man pay the hourly wages of the social investigator, the psychological evaluator, and the child's independent attorney. This created a profoundly perverse financial incentive structure that completely guaranteed the destruction of amicable resolutions. The court-appointed professionals quickly learned that their continued judicial appointments and therefore their personal livelihoods, relied entirely on generating highly complex, artificially lengthy reports that justified their existence to the state. A simple, fast agreement between two parents did not generate thousands of dollars in billable hours. Therefore, the bureaucracy fundamentally required, and actively manufactured, high-conflict litigation. If a man attempted to present independent evidence contradicting the investigator's heavily biased report, the system severely punished his defiance. Questioning the methodology, demanding the raw testing data, or pointing out the blatant conflicts of interest of the court's chosen expert was immediately framed by the judge as adversarial, uncooperative behavior. The investigator would simply draft a highly critical supplemental report, billing the father for the extra hours required to write it, and officially label him as combative and detrimental to the peaceful resolution of the custody dispute. The American man was trapped inside a Kafkaesque financial nightmare where attempting to legally defend himself was officially recorded as absolute proof of his unfitness, and paying the extortionate fees of his own executioners was the only possible way to avoid immediate jail time for contempt of court. This impenetrable administrative machinery allowed the state to effectively bypass the United States Constitution entirely, stripping men of their property, their constitutional due process, and their progeny based on the subjective whims and financial motives of a shadow bureaucracy. The legal system had successfully built an absolute fortress around the rapidly expanding divorce industry. But as the mid-20th century approached, an unprecedented cultural and economic shockwave was about to strike the nation. The post-war economic boom and the explosive rise of massive federal entitlement programs were about to violently collide with this highly efficient wealth extraction machine. The government was about to realize that while extracting money from individual men was highly profitable on a local level, creating a permanent, federally subsidized underclass of single-parent households could be utilized to justify the expansion of the largest, most powerful bureaucratic apparatus in human history. You are about to see exactly how the American family was transformed from a localized social unit into the ultimate financial collateral for a multi-billion-dollar federal industry. The transformation of the American family into a financial instrument began with a massive, unprecedented expansion of the federal government in the mid-20th century. Following the Great Depression and the Second World War, the United States saw the creation and explosive growth of federal welfare programs, most notably aid to families with dependent children. Originally, these programs were designed as a temporary, localized safety net for widows whose husbands had died in industrial accidents or foreign wars. But as the social fabric rapidly shifted and the early tremors of the no-fault divorce revolution began to fracture households across the nation, the demographic of the welfare recipient completely changed. By the 1960s and 1970s, the vast majority of families drawing massive public assistance were not led by widows, but by divorced or voluntarily separated women. The federal government suddenly found itself hemorrhaging billions of taxpayer dollars to subsidize the skyrocketing rate of marital dissolution. The state had effectively become the primary financial provider for millions of fractured homes, and the politicians in Washington recognized that this exponential trajectory would eventually bankrupt the national treasury. Instead of reforming the deeply flawed divorce laws that were rapidly destabilizing the nuclear family, the government engineered a legislative solution that fundamentally altered the relationship between an American father and the state. They decided to transform the massive federal bureaucracy into an aggressive, inescapable collection agency. The turning point in these historical trends occurred in 1975, with the passage of Title 4D of the Social Security Act. This single piece of legislation is perhaps the most critical, yet least understood, component of modern family law. Title 4D mandated that every single state establish a dedicated, highly militarized child support enforcement agency. But the federal government did not just ask the states to enforce these orders out of moral obligation. They incentivized the extraction with a massive financial kickback system that permanently corrupted the neutrality of the family courts. To understand the sheer magnitude of this conflict of interest, you must look at the mathematical formula built directly into the Title 4D legislation. The federal government offered to reimburse state governments for the administrative costs of running their child support programs, but they tied massive financial bonuses directly to the state's performance in extracting capital from fathers. For every dollar a state child support agency forcibly collects from a man, the federal government rewards that state with additional funding. This created a profound systemic shift. The state governments suddenly realized that higher child support orders equated to millions of dollars in federal bonus revenue flowing directly into their state treasuries. The American father was no longer just a legal adversary in a civil domestic dispute. He was officially converted into a highly lucrative revenue stream for the state government. Imagine if right now, in the year 2026, a man named Robert is navigating a custody modification. Robert is a highly successful logistics manager who desperately wants 50-50 shared parenting time with his children. He assumes the judge is a neutral arbiter weighing the psychological best interests of the family. What Robert completely fails to realize is that the state he resides in relies heavily on Title 4D federal funding to balance its annual budget. If the judge grants Robert equal physical custody, his mandated child support payments will drastically decrease under the state formula, which means the state collects less money, which directly results in the state losing massive federal bonus payments. The entire bureaucratic apparatus, from the friend of the court to the enforcement agents to the judges themselves, operates within a financial ecosystem that is actively penalized by the federal government if they allow men to retain their own wealth and share equal custody of their children. The system is structurally engineered to maximize the financial extraction from Robert, because his financial bleeding is the exact mechanism that keeps the state agency heavily funded. This federal mandate triggered a nationwide race to establish brutal, mathematically rigid child support guidelines. Before this era, judges had some level of localized discretion based on the actual literal needs of the child. But the federal government demanded uniform, formulaic extraction. States hired economists to calculate what it theoretically cost to raise a child, but these formulas were frequently heavily inflated, tying the support obligation not to the child's basic survival needs, but to a vast percentage of the father's gross income. These guidelines were meticulously designed to ensure that as a man's career progressed and his earnings increased, the state's cut increased proportionally, permanently linking his future labor to the extraction machine regardless of whether his children actually required that level of capital. Let us examine the step-by-step reality of how this dragnet operates in practice. Under the historical trends established by Title 4D, the concept of voluntary payment was completely eradicated. The state successfully argued that fathers were inherently untrustworthy debtors. Therefore, they instituted the mandatory income withholding order. When a family court judge issues a support decree today, the state does not wait for the man to write a check. The state bypasses the man entirely, directly legally commandeering his employer. The employer is legally threatened with severe financial penalties if they do not immediately garnish the man's wages and route the funds through the state's centralized disbursement unit. The state physically takes possession of the man's labor before he is even permitted to pay his own rent, secure legal defense, or buy his own groceries. In 1986, the federal government tightened the snare even further by passing the Bradley Amendment. This terrifying piece of legislation completely stripped family court judges of the power to retroactively reduce or forgive child support arrears, no matter how extreme or justifiable the circumstances. If a man like Robert in our 2026 scenario is involved in a horrific car accident, falls into a coma, and is physically unable to file a formal modification petition for 6 months, the debt continues to accrue at the absolute maximum rate. When he finally wakes up, permanently disabled and unable to work, the judge is legally barred by federal law from erasing the debt that accumulated while he was unconscious. The arrears become an immortal, unshakable financial phantom that cannot even be discharged in federal bankruptcy court. The state strictly prioritizes its extraction mandate over basic human survival. Furthermore, the enforcement mechanisms deployed to maintain this system are the most severe ever authorized against American citizens outside of major felony convictions. If a man falls behind on these heavily inflated, mathematically rigid payments, the state does not care if he lost his job, suffered a massive medical emergency, or experienced a global economic downturn. The arrears immediately begin accruing exorbitant, state-mandated interest. To force compliance, the Title 4D agency deploys a cascade of automatic, administrative punishments that require absolutely no judicial oversight. They will automatically suspend his driver's license, mathematically ensuring he cannot commute to work to earn the very money they are demanding. They will place automated administrative liens on his bank accounts, intercept his tax returns, seize his professional occupational licenses, and instantly revoke his passport. If these administrative assassinations fail to extract the capital, the final step is the deployment of raw physical force. The family court will issue a bench warrant, and armed police officers will arrest the man, placing him in the county jail for civil contempt. He is locked in a cage, surrounded by violent criminals, not because he committed a violent act, but entirely because he failed to satisfy a financial debt to a state agency that is financially incentivized to keep his debt as high as mathematically possible. The concept of debtor's prison, supposedly outlawed centuries ago to prevent government tyranny, was quietly and systematically resurrected under the unassailable guise of family court enforcement. By federalizing the extraction of wealth, the government successfully built an inescapable, highly automated national grid. The localized, chaotic injustice of the early American courts was replaced by a cold, calculating multi-billion-dollar machine that views the dissolution of the family not as a societal tragedy, but as a critical, highly lucrative funding mechanism. But as we move into the modern era, the sheer crushing weight of this system has begun to produce a massive, unforeseen societal reaction. Millions of men, armed with the brutal historical data of what this machine does to their lives, are fundamentally altering their behavior, sparking a silent economic rebellion that is terrifying the architects of the family court system. You are about to see the absolute culmination of 300 years of legal warfare, the potential outcomes for the modern man, and the precise strategic mindset required to survive the endgame of the American divorce industry. To survive this endgame, you must first recognize that the American legal system is currently experiencing a massive, unprecedented crisis of supply. For 3 centuries, as we have meticulously documented, the entire family court extraction machine relied entirely on one fundamental, assumed vulnerability, which was the absolute willingness of men to legally bind themselves to the state through a marriage contract. The system mathematically depends on a constant, renewing supply of high-earning men willingly walking into the jurisdiction of the family courts, offering their future labor, their businesses, and their real estate as collateral. But as the sheer brutality of this system has been exposed through raw data, historical trends, and millions of devastating case studies, a profound behavioral shift has occurred. Imagine if right now, in the year 2026, a highly successful software engineer named Ethan is contemplating his future. Ethan does not view domestic partnerships through the deeply sentimental, romanticized lens manufactured by mid-20th century media. Instead, armed with the historical literacy of how the courts actually operate, Ethan views the formal marriage license exactly for what it functionally is in the modern era, which is the most dangerous unlimited liability financial contract a citizen can ever sign. He understands that by signing that single piece of paper, he is voluntarily waiving his constitutional right to property protection, handing a family court judge absolute discretionary power over his life savings, his retirement accounts, and his future wages. Because Ethan understands the colonial history of coverture and the modern federal mandates of Title 4D, he makes a calculated, strategic decision to simply opt out. This is not an isolated incident. It is a massive, measurable demographic megatrend. We are witnessing a silent, economic rebellion where men are systematically starving the machine by refusing to provide the foundational legal signature required to initiate the wealth extraction. Historical trends regarding marriage rates show a catastrophic collapse across the United States. The state agencies, which we established, are heavily reliant on federal funding tied to child support enforcement and asset liquidation, are panicking as their primary resource pool evaporates. The industrial-scale family court system is a bureaucracy that must feed itself to survive, and when men refuse to volunteer for the slaughter, the bureaucracy must adapt its hunting strategies. How does a predatory legal bureaucracy respond when its prey refuses to enter the trap? It legislatively expands the physical dimensions of the trap. In response to this silent economic rebellion, aggressive legal architects are furiously attempting to blur the lines between casual cohabitation and formal legal marriage. We are seeing a terrifying resurgence and expansion of common law marriage doctrines and civil palimony claims. The state is actively attempting to grant the civil courts the authority to seize a man's assets and mandate future wealth transfers, even if he explicitly, verbally, and physically refused to sign a state marriage license. The courts are beginning to rely on deep historical precedents to argue that if a man simply lives with a partner for a specific duration, or if he casually shares household expenses, the state can retroactively declare him married against his will. This instantly subjects him to the exact same draconian asset division and permanent alimony laws we have spent this masterclass deconstructing. This means the modern legal battlefield has completely shifted. The defense strategy for a man in 2026 is no longer just about hiring a brutal divorce attorney after the contract is signed. It is about absolute, preemptive asset isolation before a residential relationship ever begins. Educational case studies of high-net-worth individuals reveal a massive surge in the utilization of complex defensive financial architecture. Men are learning to deploy domestic asset protection trusts, irrevocable jurisdictional trusts, and rigid, heavily negotiated prenuptial agreements. However, you must understand that even these defensive measures are actively under siege by the historical momentum of the system. Family court judges, operating under the centuries-old colonial mandate to prevent individuals from becoming public charges, routinely invalidate private prenuptial agreements. They utilize extremely subjective legal concepts, claiming the agreement is currently unconscionable or asserting it was signed under duress decades ago. The judge possesses the unilateral, sovereign power to look at a private contract signed by two consenting adults, declare it unfair by shifting modern standards, nullify it in open court, and proceed to liquidate the man's estate according to the state's default extraction formula. Therefore, the precise strategic mindset required to survive is one of absolute systemic awareness and emotional detachment. You must fundamentally accept that the American family court system was never designed to deliver justice, fairness, or equity to the individual man. It is not broken. It is functioning exactly as it was legislatively engineered to function over the last 300 years. It is an administrative wealth redistribution machine originally designed to absorb the financial fallout of broken homes by entirely consuming the capital and labor of the father. You cannot appeal to the morality of a machine. You cannot expect a system that is financially incentivized by your destruction to suddenly offer you a fair, amicable settlement. Understanding this deep, structural history is your only viable intellectual shield. When you recognize that modern alimony is not a moral imperative, but a direct descendant of a colonial tax designed to protect the local public treasury, you stop fighting it emotionally and start defending yourself strategically. When you understand that the ghosts of the tender years doctrine still invisibly dictate modern custody evaluations, you stop expecting the court-appointed psychologist to act as an objective medical scientist and start treating them as a hostile state investigator building a permanent legal case against you. You must navigate your personal and financial life with the absolute, unshakable certainty that the state is constantly, actively looking for a legal mechanism to convert your private, hard-earned property into public utility. We have meticulously traced the heavy iron chains of liability from the freezing town squares of colonial Massachusetts, through the chaotic legislative assemblies of the post-revolutionary era, directly into the multi-billion-dollar automated federal extraction grids of the modern digital age. You now possess the comprehensive historical blueprint of the American divorce industry. You see the invisible interlocking architecture that traps millions of men every single day in a cycle of perpetual debt and alienation. But the legal warfare absolutely does not stop at the borders of the traditional marriage contract. As millions of men flee the institution of formal marriage to protect their legacy, the state is rapidly constructing a new, even more insidious federal dragnet designed to capture their wealth through the simple act of sharing a residential address. How exactly are aggressive family courts weaponizing the concept of implied contracts to bankrupt men who explicitly refuse to get married? And what are the specific invisible legal tripwires you might be unknowingly triggering inside your own home right now simply by paying a utility bill? That terrifying expansion of state surveillance and asset seizure requires its own massive investigation. And we will dismantle that exact legal machinery piece by piece in our upcoming masterclass on the explosive rise of palimony and common law asset confiscation.